talking about the changes to the Canadian Citizenship Application and the new bill that has been introduced called C6. Like any other legislation in Canada, some changes will come into effect immediately, whereas others will come closer to the end of the year as well as early next year. In this video, I will explain the certain changes that will be happening immediately and exactly what Bill C6 is, as well as touching on what is going to be happening come fall as well as in the early next year. To start off, I will explain what Bill C6 is. Bill C6 is an act that is amending Canada's Citizenship Act. These amendments to the act have finally received royal assent and are now law. This bill is extremely beneficial for immigrants that are currently looking for Canadian citizenship for themselves and their families, as permanent residents can now apply for citizenship a lot sooner than before. This bill is also intended to enhance program integrity and retract certain provisions that treated dual citizens differently than Canadian citizens. With regards to the immediate changes as of June 19, 2017, with regards to Bill C6 for the Canadian Citizenship Act, in the previous act, the dual citizen that is convicted of treason, spying, and terrorism offenses, or who is part of an armed force of a country or an organized group engaged in conflict with Canada, their citizenship would actually be revoked. However, in the new act, the provision has been repealed. So what this means is that citizens that are dual citizens, they actually will face the same consequences as any other Canadian, and they will face the Canadian justice system for these crimes. In the previous act, any Canadian citizen that gained citizenship was required to intend on living in Canada after the citizenship had been granted. However, in the new act, this provision has actually been repealed as well. Now applicants are no longer required to intend on living in Canada after they gain Canadian citizenship. This allows Canadian citizens more flexibility with regards to their personal circumstances should they need to leave Canada. For example, if they need to go for work purposes or personal circumstances, they are now allowed to. In the previous act, it stated that the minister had the ultimate discretion whether or not to waive certain requirements, specifically under subsection 5.1 of the Citizenship Act, so that a minor may obtain citizenship without a Canadian parent. In the new act, minors can now apply for citizenship without a Canadian parent. Furthermore, the age requirement of citizenship has been removed under subsection 5.1. Therefore, a person who has custody of a minor or is empowered to act on their behalf by court order is now able to apply for citizenship for that minor unless the requirement is ultimately waived by the minister. In the previous act, there was no provision preventing individuals serving a sentence in the community, which would be a conditional sentence order, from being granted citizenship. This includes taking the oath of citizenship or applying this time towards their physical presence requirements for citizenship. However, in the new act, individuals who are serving a conditional sentence will not be permitted citizenship to take the oath of citizenship or be able to count the time spent towards meeting the physical presence requirements for citizenship. In the previous act, the minister had the ultimate discretion to grant citizenship to an individual to relieve cases of unusual or special hardship, or to reward services of an exceptional value to Canada. However, in the new act, individuals who are stateless have now been added as a standalone ground that can now be considered as a discretionary grant of citizenship. This new revision is very beneficial for immigrants who are going through hardships who are trying to gain citizenship in Canada. In the previous act, it was determined that the department has reasonable measures to accommodate the needs of citizenship applicants, though there was no reference to accommodate persons with disabilities in the Citizenship Act. In the new act, there is now a requirement to take into consideration reasonable measures to accommodate for the needs of an individual applying for Canadian citizenship who has a disability. This has been permanently changed in the Citizenship Act. In the previous act, there was a requirement for applicants to maintain the conditions of Canadian citizenship from the time they apply until they take the oath of citizenship, which only applied to applications after June 11th, 2015. However, in the new act, the requirements are now for all applicants, including those who were before June 11th, 2015. This allows for consistency within applications for Canadian citizenship. With regards to the changes for fall of 2017 and early 2018, there are many implementations that will not take effect until then. Such changes include the time spent within Canada before applying for Canadian citizenship, revisions to the required years of filling income taxes that match the physical presence requirements, revisions to the time spent prior to becoming a permanent resident, counting towards citizenship, and more. Ultimately, all of these implementations and revisions and the implementation of Bill C has had a very positive feedback from immigrants trying to gain Canadian citizenship. Ultimately, Bill C has made it easier for permanent residents to gain Canadian citizenship through the implementation of the Act and the amendments. If you need help with gaining Canadian citizenship or have any questions with regards to Bill C6, we can help you at Akrami & Associates, and if you have any questions, feel free to contact us. Thank you so much, and see you soon.